My take on that particular piece is, again, I think I was checking with Mr. King and company today. I think we need to take advantage of the IT Act, which has been promulgated, and try to do an internal check and then figure it out. Because at this point of a time, these acts basically we kind of read and leave it there, but we don't really go and get them validated and certified, keep it records ready, unless someone comes and knocks my door and says that we found that you are violated, now prove me that you are not guilty or guilty. That's where we'll start. So I just started looking at some other aspects, if it can be applicable, and that's where might be giving me some kind of a confidence, or the board of directors who need to sign off in the IT Act compliance and saying that I'm compliant. Otherwise, I don't think they would blindly sign up for that. So that something might provide some kind of internal controls to the organizations as they go forward.
Yeah, offline I'll have a chat with you, because my fear is exactly this. I think it is being looked at more culturally, hey, telling the employees don't breach data, and very preaching kind of a thing is the way the IT Act is being handled. Not like a Sarbanes-Oxley compliance, where you have a process to ensure that my increment is not shared with him or her, or my age is not, or whatever, the 4 aspects of SPDIR. So that's exactly my point actually. How are we, the preaching part I'm clear. I think all organizations are talking to their employees, don't share information of anybody with anybody unless there is an approval for the same from the employee concerned and things like that. So I think offline I'll have
So we can discuss during tea time so that we can have more questions. We saw some more hands. Any more questions? Okay.
I'm Denise Gardenia. I'm working in a legal department of medlife.com. Basically, when we talk about privacy, and now that things are coming up with the healthcare coming in the internet. So I would want to know that, yes, we do perform legal due diligence with regard to the cyber laws, but we make a privacy policy, all those things that, okay, we'll use our information here, we'll use our information there. What exactly, as a legal person, am I supposed to make sure that if there is a breach, I protect my company?
I'll just take first start and then we'll give it to people. As a legal person within the company, I think you should raise a concern to the board of directors and saying that this is observation made in the ground level. So they need to be aware of it, it's coming their way.
Yeah, we make that. When we do our diligence and everything, we put the safeguards that these are the things to be done. But on a proactive level, like at the moment, the laws are not in place. There are meetings going on in which they are coming up with the laws. Like I think on Tuesday itself, they had a meeting last. So they are coming up with it. But as a proactive measure, what are the safeguards because healthcare, we have the most sensitive data. The diagnosis, we have other things in place. So what exactly safeguards would be legally we can put in so that we protect ourselves?
I think this is a part of third session. So if you want, can I butt in?
Yeah, sure.
I couldn't resist myself being a GC form. I think to answer your question, the 5 essential templates what Baker and McKinsey took out is universally applicable, which is that set the tone right at the top, as you rightly said about the board of directors. Going for regular practice trainings. 3rd, put systems and controls in place. 4th is have a PDCA in place, plan, do, check, action. And finally, once you find that you need to do a review mechanism, go in for it. Set your time, whether it's 6 months, 1 year or so.
Yeah, good, thank you. I think you had a question.
I just wanted to point out, you're absolutely right, it's covered in the next session. There's actually a specific provision on the, we keep vilifying our laws, but I think the SPDI rules are fantastic. And there's a specific SPDI rule which gives you a safe harbor. It says, if you have the ISO IC certification done, then if there is a breach, you will actually be able to use that to cover yourself. So that is specifically mentioned under the SPDI rule.
Yeah, we can have it offline, maybe so, over a good cup of tea and coffee.
Okay, my name is Varun Maheshwari, and I kind of interpret the privacy laws to my organization. So when we are talking about this big data, I do not have a technical expertise of what big data is, but what I understand from the discussion right now is that the technology of big data, the concept of big data is that it's taking data feeds from various information databases and doing some analytics. We talked about that there is no kind of legal framework or regulatory guidance on it. But if I take a step back to say when we are generating those databases, we do have choice consent mechanism in place. Why cannot we take it from there and then maybe implement it or push it up so that to me personally, I don't see that we need a specific regulation or prescriptive regulation on big data. So, any thoughts and comments on that?
One of the major problems is that this data, analyzed data, if it falls into the wrong hands, it can actually have a much strong impact. An example, I'll tell you, when I was in telco, I heard one use case. Somebody came and said that normally we buy 1 million SMS at say 40 paise per this thing. Conversion is 2%. So one company came and said, I know exactly the 2%, pay me 10 rupees per SMS. So we asked, how do you know this 2%? They said, let us take an example of a homemaker. So how do you identify homemaker in the entire subscriber list? So we said the CAF form. Most of the time, CAF form is not correct. My wife's phone is in my name, so that may not be the right. One small example they said, let us look at the morning 8 to 10 and evening 4 to 6. Is this person cutting a cell site? In the sense, are they in the same cell site or are they moving? That is the first call they are taking. So from there, your data is come to around 5%. From there, they will look at what is the interact pattern. Are they browsing cooking sites, shopping sites? Then they reduce it. That data, you can create a use case for many other group of people or type of people which you can target if something is badly need to be done. That is where the problem. How do you secure this data? And how do you use the outcome of this? That is where the problem is.
The second I want to add to the point is just one last point. So is that the way privacy notices consents are designed, they are often made to confuse people who are not very diligent. So many of us just sign, and the way they are designed is you will not be able to avail the service unless you tick yes everywhere. So those kind of issues are also there. In fact, there's a standard which is likely to come on that also on the ISO and privacy notice, consent, etc. How to design in a user-friendly way. So that is an area where data goes beyond to third parties and it proliferates thereafter. So we do have time for. We are running out of time.
We will take it offline. With that, I thank you, Srinivas, and your excellent team of Sunil, Ramesh, Maria, and Vipul. Let us have a big round of applause.
Thank you.
And before you leave, sir, a small token of appreciation which is coming through the IAPP way. May we have, and Dr. Guppy, can we have you on stage, please? Sunil. Yeah. Maria. Srinivas. Ramesh. Thanks. And Vipul. Look forward to having a 10-minute tea break session and we assemble back 5 o'clock. Thank you, everybody. May I have your attention, please? With an energizing cup of coffee or tea, I am sure that the next panel is going to really get all the ears of the august audience. The panel is titled Privacy in Doldrums. I couldn't have agreed with it much more, given what we were possibly post pre-1991 and where we are today. Seems to be an explosion of, information and data, and that's where it's scary. It can be used for good measures, it can be used for ulterior motives also. Having said that, without dwelling more into the subject, may I call on stage V. Rajesh Kumar, Lead Manager, Privacy and Data Protection, Infosys. A big round of applause, please. As I said, no conjuicy, please. Thoda tali dil se. Rajesh, I have to keep you in good humor here. May I also have on stage, please, Indraneel Chaudhary, Founder and CEO of Explosion and one of our sponsors. So again, a big round of applause for you. I have done my part. Could Could we have on stage, please, Mr. N. Vijay Shankar, Cyber Law Specialist and E-Business Consultant. Good to have you, sir. Wonderful to have you back. Kavita Babu, this time I took the correct. Please join us on stage. She is a senior attorney, Microsoft India. Why there is no class for her?
One more chair in the
And finally, could we have Suchinto Chatterjee? Oh, again I slept. Maybe I had a banana in the morning. N.S. Napinai, advocate and founder, Technology Law Forum.
I want one more chair on the podium.
Yeah. In fact, I'm, I don't know, something to do with. Rajesh, would you be comfortable with 45 minutes or how do you want it?
Good evening again to every one of you who is part of this event. And I would also like to give a special thanks to each one of the panel members who was part of this particular topic. Thanks, Ramsar. So to start with, privacy in doldrums. And then there is a small hyphen and getting into adopting to information age. Okay, so this topic really struck my mind when we happen to have our Honorable Prime Minister, giving a Digital India launch, and we are getting into a platform of talking about more on a cyber security, and which is also one of the core tagline of our, the entire event is. But that's in the third place. But even before we go with it, there are two other components that needs to be addressed. One is privacy, and the other one is data protection, and then goes the cyber security. So data protection, we had eminent speakers on the earlier panel who spoke about it, but the base still left unanswered. So we would just drive on those issues and see where do we stand. Is India ready right now, to go ahead with this Digital India initiatives? Are the basic individuals or the rights which are being available under the constitutional law as well as other laws, are they in protected? Do they right? Because I've been telling most of the people, we used to construct houses earlier and we used to have all bricks around us, so that we were quite sure that what's happening inside the house, you don't want the others outside to show. But in the name of luxury now, things are changing. No more bricks. Everywhere is glass. So we are getting away. I mean, even the people's recognition on their own individual rights, are they not aware because it's their own negligence, or is it because the law is totally absent? Or isn't the government taking any major action there? So to drive on that, there are certain core topics that we have been hearing in the past few, and we will try to drive and recap on it before we go into the corporates, which will be paired by each of the panel speakers. So, sir, this question is to you. I'd just like to know, on the Aadhaar card. I mean, even 3 days back, we heard on the Times of India that the Kavi, one of the consulting company, was having access to the Aadhaar database. I mean, you talk Aadhaar database is just not names or just numbers. Also talks about biometric data, which is sensitive information, which is defined by law. And the UIDA says it's illegal. That's not been allowed. So, isn't there been any accountability? Who needs to take responsibility here? How is Aadhaar whole initiative driven? If you could just shed some light facts, which can be supplemented by Ms. Napinai on this.
Thank you, Rajesh, and good evening, friends. See, Aadhaar has become actually a symbol for anything to do with privacy. The reason is, several things have gone bad. Basically, when the data was collected, it was not properly protected. We have got Aadhaar cards issued to coriander seed, something like that. So there are various issues which have come to the fore. But what we need to remember is, Aadhaar, as it was conceived as a project, and what we are seeing today, they are not the same. See, when Aadhaar was conceived, in the very early stages when we had discussions with Mr. Nandan, one thing was very clearly made out, that what was being created was a national ID database. And it would be available for query from various users who would be service providers. And when when a customer approaches a service provider and says, I am Vijay Shankar, I want to open a bank account, my address is so and so, the bank or any other service provider was to send a query to UIDAI database with my biometric. This biometric, please let us know if does it match with Vijay Shankar. From the other end, the only answer which should come is yes or no. This was the original concept. That is, database should be available for query by authorized service providers who will input the biometric data and one question, which will be one of the 13 parameters or something like that. But what has happened now is Aadhaar has become an ID card. And it is printed out. The first mistake was done by UIDAI when they sent the Aadhaar card with a perforation cut here, which indicated that this has to be used as an ID card. And most of the service providers today just ask a photocopy of what you have, or if you input that number, there will be an e-Aadhaar which can be downloaded. This was not at all envisaged in the original Aadhaar this thing. Data was not supposed to move. Let us forget about the loss of data at the registration stage. That was mismanagement of the registrants kind of a thing. Suppose that had been taken care of, data would have reached UIDAI without any problem. And data would never go out of UIDAI server except by this yes or no answers. But today, that system has been changed. And with 70 crore Aadhaar cards already issued, 70 plus, the privacy of those 70 crore has already been lost. There is no point in discussing today what will happen to that. With biometrics, my name, address, everything is already available, and it would have been perhaps downloaded by several terrorist groups and others who might have already built up a parallel database. I have to go with that presumption, which means that that is given. Privacy has been lost because this is ultimate, because with my biometrics, all the details have gone. I cannot recover. I cannot change my biometrics. I can change my email address today. I may change my mobile number, but I cannot change my biometrics. So that is the situation we are in. Whoever is responsible, that is a different issue. We have to live with this. And privacy is always linked to this identity. So for example, in India, we don't have a privacy law, but still we talk of privacy, and there is data privacy, and all the IT people are here. What we are doing in India is, we are only trying to protect data which consists of personal information or sensitive personal information, which is in the hands of an organization. The data subject will be asked, how do you want me to protect this data? And based on that contract, the company is supposed to protect. This is what Information Technology Act has envisaged. It's all contract-based data protection which is being offered in India. The contract is either implied or express between the data subject and the company. And based on that, data is being protected, not privacy. Privacy protection is a human right issue, which is the lawyer's domain. It is not the IT company's domain. IT company is only interested in what data I am having, I have to protect. Even if it is not PI, I have to protect. Remember, if I am a CISO, I will protect non-PI also. But when it comes to PI, we are saying that by protecting this, I am protecting the privacy. It's an indirect protection. So don't expect anything more than this as far as privacy protection in India. But if something goes wrong, what has to go wrong? In the cyberspace, the data is being breached. Okay? And because of which, one individual will stand up and say, my health data has been misused. Okay? Now, what has happened here is the identity of the data holder, which is along with the data, has been breached. That is why most important aspect we have to remember is, if data is de-identified, most of our problems of privacy protection is protected. Unfortunately, Aadhaar is directly related to ID. So if a data is linked to Aadhaar, then It is an identified data, and if it's breached, we are having problem. That is the situation which we are having in Aadhaar now, and hopefully we will do something to live with this without much of a damage. That is, identity theft related problems can be managed, but privacy is lost. I suppose every user of Aadhaar will only use biometrics. Today they are not using biometrics. They look at your face and the photograph. That is all the ID. Rest of it, they get a copy. What I want is they should stop identifying people and doing KYC with the photograph of the person as the identification, but use the biometrics. I have asked many banks today, they don't have a biometric device in the bank. I have asked them, if you want a KYC, then take my fingerprint and you find out who I am. Okay? They have not equipped themselves. I think this is what privacy people should force Aadhaar, that every user must use a biometric device, and through that only do KYC.
So, Ms. Tapinai, so just wanted to, if you can add how to bring accountability and transparency in this process. Probably if you can shed some points on that.
Before we go into that, one short break to ask a quick question of the audience and of the people on the dais. How many of you all have the Aadhaar card?
That's a need.
Okay. So at least a couple of lawyers here don't seem to have it. You don't have one. So at least 3 out here and some out there. The reason I ask for that is 2 things. One, I do not agree with Navi when he says that you must, one, go with biometrics and, go with the Aadhaar flow. If you look at data per se, where do we really come from? Where is our position as individuals? It's 2 extremes. One is of fear, which is what as, very paranoid lawyers I think we have. And the other is this overzealous, need to share everything about your life. So when we're talking about privacy, we have this dichotomy where the same person will want to go and share each and every minutiae detail about themselves on social media, and on the other hand talk about my privacy, my right, I like to be left alone kind, right? So when you look at it from the perspective of Aadhaar, the way I see it is, one, it cannot become a forced stand. It has to be voluntary, just the same way as how I can decide to disclose my entire life online and say the government doesn't have the right to take my biometrics or other details. That's the issue of choice, firstly. The second aspect is what you raised, and which is primarily the reason which the Supreme Court has taken the stand with respect to Aadhaar, is that in the dichotomy again of accountability and transparency. A stark example comes from one news report which was given about what the government did in or about 2013. In the name of transparency, they put up just about every kind of data of people who primarily in that particular database, it was collected based on the employment exchange kind. So even the bank account details were put online. So this is the extent to which transparency can lead to the other extreme of accountability. So that procedure, any waiver of a right has to be on the basis of settled procedures which are workable and which are going to protect the rights of the persons who you are asking to waive certain rights. So in this case, like the first aspect of what Navi mentioned, that the absence of procedures is the reason why the Supreme Court has said that this has to be relooked, but it has first raised this issue of privacy to be decided upfront. But I think the issue about the right to privacy as a fundamental right is in itself so fundamental that they just have to go with the flow of the various judgments for the last 30, 40 years. If they are going to diverge from that, we're all in for trouble. Just to quickly touch upon the other aspect which Navi mentioned is about the statutory and constitutional right. I would want to very clearly say that we would definitely need, not just want, need it to be a constitutional right. But having said that about privacy, does it still entail other going forward? I would say not quite so. We're really not prepared at a government level to understand, appreciate, and be responsible with data.
Thank you. Thank you. Mr. Indranil, this question is for you. I've been, as being part of the compliance organizations, you have been into most of the companies where you do auditing and other things. So can you give certain scenarios without no names disclosed? What are the gaps that you have normally found, as per the IT Act, and what you have seen? So if you can just share one or two, that would be really interesting.
You don't even have...
Yeah. You can use this. You can use this.
Okay. Essentially, I don't even think you need to be a lawyer or you need to be able to access a company's internal information to do this basic assessment. Take the top 10 hospitals in this country by revenue, market cap, whatever you want to. Go into their publicly available website where they're supposed to be uploading their privacy policy. See how many of them have uploaded the privacy policy to start with, right? If they have, then as per the sensitive personal data or information rules of 2011, I think it was notified in April of 2011, so it's already been 4 years and a few months. It specifies what are the things that the privacy policy needs to talk about with regard to what kind of personal information, what kind of sensitive personal data or information do you require people to provide, what kind of consent do you take, what right do you give for them to willingly change that information or ask you to take it away. All of that is specifically mentioned. So you can go in and check how many of the privacy policies actually have that. And I just took the name of hospitals because it's a place where a lot of us provide information which is inevitably sensitive and personal and is directly covered under the SPDI. But you can test this out with your, say, previous employer. You can ask them that can you please confirm whether you have deleted my bank account details which was given to you as a part of the joining formalities. Because in most cases, when you join a company, the company opens a salary account for you, right? Now that salary account is a bank account detail which you carry with you for as long as you want to. So your company takes your name out of that salary account list so that it does not remain a salary account anymore, but your banking transactions continue to be done through that same bank account. Now, what the SPDI rules very specifically state is that you cannot hold on to information for longer than what is required, which essentially means that if I've left a company, say, in 2013, now in September 2015, it'll be a fair expectation to say, hey, why do you still have my bank account details stored up along with 5,000 other previous employees somewhere in your database? You don't need it. Can you establish it to me that you've removed it? So we do assessment for a living, and so these are the kind of things that we look for. And the answer is that in most cases, basic fundamental requirements, like I was mentioning in when the lady there brought up the issue of what kind of safeguards can we take. Now, there is a specific rule under the SPDI rules which requires you to take certain guides you to take certain kinds of ISO, IC certification, which will provide you with a justification in case there is a breach, because that's what the framework is supposed to be. And if you do not use ISO IC, then you have to go and get your own framework certified. That's mentioned. You need to audit it on an annual basis. Now, all of that requires compliance to be taken seriously, which unfortunately most Indian organizations and multinational corporations operating in India are not willing to take. Now, the day they start taking compliance seriously, when it is not paid lip service to, they will actually get that certification. In 2012, many clients of ours or many potential clients of ours told us, hey, it's just come in, it's too early. It's 2015 now. It's been 4 years and a few months. I will not embarrass anybody out here,
but you can ask yourself that question, how many of you have got that certification? How many of you have got yourselves audited on an annual basis, which is required under law? And if you've done it, will you still be scared of a potential breach and the implications? Because the implications automatically come down under the penal provision for, because this is the reasonable practice which the law specifically states you need to take. This is my observation as an outsider who assesses organizations for IT Act compliance from a legal perspective. We do not have any skill to do it from an IT perspective. And what we have noticed is that in most cases, if the SPDI rules are being followed to the T, and if things like, and I just mentioned employees because it strikes a chord with everybody, but for third parties, for example, when you set up a new vendor, you ask the vendor to give you a copy of a blank check. In many cases, which is cancelled. You have to cross over it and write cancel. I'm not quite sure why that's required. I'm sure there's a finance professional here who will be able to explain why it's required, but it is. Now, when you provide it, the first thing that you do, and that in itself would have been fine because, India does not have a privacy law. It would not have got covered by an IT Act if you kept it in a file. The first thing that your company would do is scan and put it up in some database, and the moment you scan it, it becomes an electronic record, and therefore is covered by the IT Act. Now, when you have, for example, if you have not used the vendor for the last 2.5 years, it's your obligation to make sure that check is deleted from wherever the scanned copy is kept. Is there an internal process? And why I'm bringing all of this up is many organizations have fantastic policies. What we do is we just take the policy and see whether they're actually following it. So do you have internal processes to actually make sure that this is being done? So I don't fundamentally believe that there is a huge problem with the Indian privacy law. The problem is with like Mr. Navi mentioned, it is fundamentally a contract between individuals that you're entering into. Are your contracts being properly executed? And then, of course, are the enforcement mechanisms enforcement systems really interested in enforcing the law? Or are they really interested in coming into the limelight by picking specific clients on specific occasions or banning 800 porn sites or whatever went by that name? Is that the purpose behind the authorities? Are they supposed to execute the IT Act? It's been a long enough time. The IT Act itself is about 15 years old now. The SPDI rules, which really gave it the teeth that was required, is 4.5 years old. I think there is enough available in the system for us as a country to get ourselves completely geared up and create the framework that is required to deal with data privacy. The question is, are we seriously interested? Are we really just trying to make sure that we don't get caught if there is a breach? And that's essentially the point that I wanted to make. Thank you.
Thank you, Internal. So just to go a little bit deeper into the IT Act, I mean, we were seeing a lot of issues on 66A. So this question is to initially Mr. Navi is, can a privacy right, be the perfect answer to balance the right of expression as well as anonymity? If you could also shed some lights on the latest encryption policy that has been tabled, and probably Ms. Napinai as well as Kavita could also shed their lights. So if you can start with it to address that.
So right to privacy and the freedom of expression are always related. One ends where the other begins. So freedom of expression is essential for protection of democracy. As far as right to privacy is concerned, it is always in conflict with national security. So I feel it doesn't enjoy the same status as freedom of expression. Freedom of expression to me is more valuable than the right to privacy, particularly when it comes to sharing data within government for national security purposes. I'm not talking of privacy breach between the individuals, which needs to be protected. So this is the fundamental difference between freedom of expression and this. Now, what Information Technology Act does is basically to protect data. So obviously, it addresses one part of it. This section 66A, everybody in India, including the Supreme Court, said that this curbs freedom of expression. But I have always been asking people, if I send an SMS message to you or an email to you, where is the fundamental freedom of expression come into this picture? Section 66A was only related to sending of messages using a communication device or an email. I don't know how everybody interpreted this as freedom of expression and it has to be protected, and the judge said that any information sent is pertaining to this. So there was a large-scale misconception involved with Section 66A because the police did not understand it. Police arrested people for Facebook post and Twitter post under Section 66A because the policeman is saying it belongs to 66A. I will not accept it. I would have told the policeman, you are wrong. So nothing wrong with 66A. This is a one-to-one communication, not covered by freedom of expression, but still it happened, went up to Supreme Court. Supreme Court has now scrapped it. And another bench of Supreme Court later on said, we regret some law like this should be there. Okay, and I hope government will bring in some change. Okay, so this will carry on. So this is my take on Section 66A. It has gone, but it has to come back because phishing was covered in that, spam was covered in that, and now all that has gone. Okay, and extortion messages sent on SMS was covered in that. Yesterday we are seeing extortion messages which company executives are facing. That would have been covered under Section 66A. Twitter message of Mehdi Masroor was covered under Section 66A. That was not freedom of expression. See, security will always win the battle against privacy because only if the community survives, I will survive as an individual. So I feel we need to find a balance between security and this. I don't have problem in finding the balance between freedom of expression and privacy, but balancing security and privacy has been a problem. I have always been telling that the problem can be solved if we adopt something which I have called it as regulated anonymity. Others may call it by different names. Anonymity can provide privacy, but when it comes to national security issues, if you can regulate that anonymity, then you will serve both the purposes. Now, how does regulation has to happen? I don't trust the government to do that regulation. So there has to be a body which is perhaps not fully governmental, but which is filtering mechanism. Whenever there is a due process, so you have all heard of the term due process for release of information. That due process has to be managed by a body so that information is essentially anonymous, but these licensed anonymizers will be knowing the mapping of an information to this, which is regulated. This is what is the concept I have, in fact, put up on various forums also. Then only we can find the balance. Otherwise, freedom of expression gets a priority towards right to privacy. Others can add, agree, disagree with.
So this is a pretty interesting and extraordinary time that we live in, right? And I want to take a couple of examples. Last year in November, when the good folks at Sony Entertainment went into work, they realized that some of them could not access their computers, some of them could not access their email, some of them could not access their network servers. And of course, there was a large investigation about what happened, and the end of the investigation found its way right at the end of the Pacific Ocean. And the world realized that there was a state-sponsored attack, a cyber attack, on a company, on a private company that was expressing its right to express freely. And this was about that movie, The Interview, if you remember, which is actually a pretty funny movie about how two journalists go over down to North Korea and try to interview the dictator, Kim Jong-un. And of course, they didn't take that too kindly and went ahead and attacked a private company. Now, Sony has been criticized about their initial reaction because as a private company, they have legitimate concerns about liability. But even President Obama in one of the press conferences took objection to them and said they should have probably consulted with him first and asked them not to be conservative about their ability to express themselves freely. And one of the remedial measures that were taken was that Sony banded with Google and Microsoft to actually be able to broadcast that same movie online on the internet to users who wanted to watch it. So the internet created the attack. The internet was also the solution, right? And I'm taking another example of what happened in earlier this year in France at Charlie Hebdo. We saw the horrific acts unfold on TV. And the attacks were again against two journalists who were expressing their freedom of expression. And the internet was used by these terrorists to evangelize, to organize themselves, and to also take claim for the attack. And interestingly, we got a call at Microsoft from the US FBI. We were served an emergency order because it just so happened that the two suspects at the time happened to have Microsoft email accounts. And we assessed the order, we assessed that emergency order, we evaluated it under the provisions of the law, we looked at those email accounts, and we released the information to the US FBI all within 45 minutes. And this was done legally. And that information was then handed over by the US government to the French police, and steps were taken to nab the terrorists, and everybody knows what happened. So the internet played a great role over there. But there are due processes that were followed, and it is possible to follow them. So all of these incidents sort of created an explosion. We saw China trying to regulate, we saw Russia trying to regulate, specifically in the areas of national security and data localization. And that's created quite an interesting explosion. If you actually look at a heat map of the world, of the various countries that are either recently regulated in the areas of internet governance or content regulation, or in the regulation of encryption laws, it's a pretty warm world. And we're there too, our country is there too. And it's pretty interesting how even the FBI director, the US FBI director, is calling for relooking at encryption laws. France is calling for relooking at content laws, and so is UK. They're looking at relooking at encryption laws, and this is causing people all over the world and customers of ours to ask a very pertinent question: what on earth is going on? And why is this happening now? And it's really important that us as an industry look at this and understand what is going on, because it is that will help be a big key to contribution of what the solution could be. And part of the reason why a lot of this is happening is because of one person named Edward Snowden, who decided to take 4 laptops with him, sit on a plane, go off to Hong Kong, and then later to Russia, and publish these documents, which the world got to see. And the world realized that there was a massive breach of trust, and trust was undermined, and we lost our faith in government. And I think it's a given that this is a war, wars are fought over borders, and there cannot be a conversation on national security without this conversation on cyber security. So it's really a question of creating a balance between these two, and we need internet laws, but we need good internet laws that have some fundamental principles in place, fundamental values in place, and then all of us as an industry need to make sure that we translate those values and principles into the commitments that we're making to our customers in our contracts, in the way we deal with subcontractors and vendors.
Thanks, Kavita. So, Nabinai would like to.
Yeah. In fact, I would put it this way, that the freedom of expression and privacy are two ends of the spectrum, So where you are willing to give up certain, waive certain rights and put certain ideas or thoughts or, your position forward, that is where you are waiving your right to privacy to put out whatever you want to. Privacy, the other extreme, the autonomy which the courts have expressed as the right to be left alone. is the other extreme to say that I don't want to express anything. I don't want anyone else expressing anything also about me. I just want to be left alone. To what extent that right can be enforced and balanced with the right to freedom of expression, and how far a government can go wrong, I would say, came out in the encryption policy. If you look at the encryption policy, it was not really about social media, WhatsApp, etc. But I would say it was a very good thing that the addendum with the explanation came later, because only when it hits an individual on a personal front, they rise up in arms. As long as it's generic and it is not affecting them, or they do not understand that it affects them, they don't really raise their voice on it. Thanks to this misconception, or probably rightly so in the beginning, and with the furor that came out, with social media being part of the encryption policy, it came to the public limelight. But if you take the social media aside and look at the encryption policy and the terms set out therein, does it really warrant giving up so much of our right in the name of security? Because everything that, if I go back to basics, I will say that society is a social contract, which every individual has entered into for his sake, for his protection. So to what extent are we willing to waive rights emanating from that social contract in the name of security? And to what extent can we expect government to be responsible in implementing these provisions? I think this is where the real disconnect is. We cannot, or we are in a position where we are unable to trust the government to enforce these laws or policies in a fair manner. And 66A was the example of that. Like Navi rightly said, 66A was not intended to be tagged with sedition every time. It was intended for a completely different purpose. In the list which Navi mentioned, I would like to add one more, which is cyberbullying, because cyber stalking was also covered under this. But now we have a separate law for cyber stalking. But cyberbullying, and if I tell you some of the names of people who have been victims of it, they're like news persons. It's not just actresses and singers, but very prominent news anchors were victims of cyberbullying, and all their cases were scrapped with the scrapping of 66A. So it's like throwing the baby out with the bathwater.
Thank you. So with the interest of time, Mr. Ram has already highlighted the play card of 10 minutes, with all due respect. So I'll just try to talk on only two more questions. One, I would like to, Mr. Suchinto, from you, I wanted to understand that India is trying to get the EU adequacy status. But that's a base. And that's where most of the economic things are happening across, and most of the service providers are surviving in India. Are we there? Because if we are trying to take an initiative, something like Digital India, and we are trying to go, and going forward, we are not going to talk about a normal malware attack. We are not going to even talk about ransomware attack, as pointed out by Mr. Navi and Apinay. We are just talking about cyber warfare. We are talking about Zeus. We are talking about something which can put the whole, and that's one reason why in the security area you have a term called as APT, Advanced Persistent Threats, that is already there. That means every organizations are already exposed to all these threats, and data are moving out. It's the only thing is nobody has come to know about it. So the day they become aware, it comes out as a breach. So probably if you can just shed that light on the adequacy status.
So as Navi said, that mostly we are governed by law of contracts. And why I say that is because of the offshoring industry being so large in the country. We've always been compliant with the data privacy requirement of an offshore location. So I think the larger discussion today has been about data privacy and privacy of individuals inside the country. But I think we are, as businesses, more compliant for an offshore location. because the compliance process is well defined, the audits are very well defined, and commerce drove the requirement for each business to be compliant with. And I mean, I would keep names out, but I've been part of a very large offshoring business myself at one point, heading the legal. And you know, one of the biggest concerns of the outsourcing unit was to read the contract and see the compliance section was clearly understood. And I'm talking about 9 or 10 years ago. So I think that gap is not so huge. The gap is local. And I mean, going away from just what the main topic is, I think the legislation requirement may be over expectation. This is my personal view. Under the Indian Telegraph Act, we had a postcard and we had an inland letter, and you could always write a letter and put it in an envelope and seal it. When you wrote a postcard, you knew the whole world could read it. So when you write on social media, we all know anybody can read it. I think the concern today really is what happens to the data that I share with a social media platform? Where does that data go and what happens? I think the preceding session had very interesting observations, and we did hear some people say we don't need over legislation. But we definitely need process, we definitely need compliance, and we definitely need people to understand. So to me, the primary requirements are consent. Consent both to use the data or to erase the data. So when a transaction happens, why would my telecom company not erase the data? Or why would the credit card company not erase the data? Or as Indranil said, if I left the company, what do they need my data for? It is not required. So I think that is the requirement today. Kavita was...
And enforcement to make sure that whatever laws are existing are implemented. You like you rightly said, you don't need more laws, but you need correct implementation of existing laws.
And in the meanwhile, I think a good standard of measure is perhaps what exists in the world today, which is standards. We have, standards that are born in the cloud, like the ISO 27018 standard, which, it focuses primarily on privacy that, it governs cloud service providers and all of this big data stuff that we've been talking about this evening. And the principles are very clear under those standards. There has to be transparency about what kind of data is being collected, and that you can use it only for the purposes that it's being collected for. There cannot be you cannot use that data for advertising unless consent has been provided. What happens when there's a breach? When am I going to inform the person who's affected by the breach? There are clear principles. And I think as businesses, we need to think about who we are partnering with. Who are we making appointments, who are we appointing as our vendors? And think about, in the absence of protective laws, think about what are those standards that their technology products, offer in their contracts. What are the standards they adhere to? Are they being audited regularly or by independent third-party auditors? Are those audits verifiable? Will they share copies of those audits with their customers? These are the kind of questions you need to be asking, the various companies that you partner with.
And on the issue, the larger issue of data privacy, just wanted to highlight something which is relevant in the general context and is something that will inevitably come to India sooner rather than later. There's a mention definitely under the SPDI rules, which is the right to be forgotten. Now, most of you would know about the case in Spain, where Google was told that they will have to delete all information that somebody says they don't want in the public domain anymore. The issue that has now come up, and what France has said, is that that right to be forgotten is a global right. It's not just a right that is available within the European Union. So which means that if I want my information to be deleted, Google will have to actually make sure that the information is not available through a Google search, not just in France or Spain or UK, but also in India and US and wherever else. Now, that brings up a very larger question of how private is data privacy? Does it mean that I have the right to seek everything to be forgotten about me. So the drunken brawl that I had in the 4th year of law school, and gladly posted as a part of my Facebook post at that point of time, am I, as now the general counsel of a large corporation, allowed to make sure that that information is deleted? Or is a future employer or a future client allowed to to know this piece of information and use it against me in some forum or the other? So when you're trying to probably discourse on drunken driving or something like that, So the issue is that, this entire concept of privacy is so global and so transborder that, it is probably very difficult to legislate and stop your, and make governments ensure that you're actually, your privacy is actually being protected. I think Ramaswamy just made sure that the mics don't work.
So, yeah.
As you have in the tax regime that you would essentially do bilateral treaty, I think it's now definitely required from the European perspective that a national level treaty has to be entered in with the European Union to be at par and make sure there is no overlap or disconnect.
No, but that's the fact. But are we qualified to be identified as an adequate? I mean, we are just talking about the EC directive that was in 1995. Correct. But what about the new GDPR that comes into, and the whole world is going to shift its regime? We are not even 20 years back, law itself, we are not been fined.
That's why I said, look at the tax regime, taxing asset being sold as...
That works because the governments get money.
So,
they're not that concerned.
So as long as there is will, and I mean adequacy, yes, there is none, but I think if the government will is there, and I think the pressure will come from the European Union. So I think that would lead to some kind of growth.
Great. I mean, even European Union is kind of entering into a sort of an umbrella agreement with APEC, trying to create a common framework for cross-border data transfers.
Even in the US...
No, they are in the final stages of negotiations.
So even in the US, they are trying to discuss whether the federal law should be there because each state is now legislating on its own. So they are trying to develop a federal system. Fine. So I think it is bound to come.
That's true. Okay. So...
the mere fact I am here means that the time is up.
So probably we can have one question, and after that, if there is any further questions, you can have all the panel members available after the. So please, one question. Anybody? Or if it's being kind enough. Yeah, Karan.
Hi, I'm Karan. I'm from Infosys DPO team. I had a question for my Microsoft panelists. The encryption policy, which was the draft policy, which has been taken away, didn't see any company actually come out with any tweet or say a suggestion. Everything happened so quickly. People tweeted, I blogged, and everything was good. But
is your name Karthik?
Correct.
We saw your tweet.
You did?
Yes.
So your right is gone.
No, so, but is it being seen by the right people?
So
okay,
this,
my question is, sorry, what is the stand of companies when the policy says 90 days keep the data, encryption, I'll tell you this is the algorithm, not the minimum, but this is the maximum length of the bits. So this is what you have to apply. Nothing came from the company.
So I think first of all, 24 hours is not enough time to digest a policy of that nature. But on that specific bit, I think from our perspective, you can't have a max, it cannot be a ceiling approach, it has to be a floor approach. Technology is moving at a rapid pace. And different sectors have different needs, different kinds of data have different needs. So it is probably best in the interest of innovation and security that goes with that innovation to go with a floor approach rather than a ceiling approach. But 24 hours is not enough time to, but we're all on it. We're all looking at it.
Okay, thank you. So I'll take this opportunity to thank each of the panel speakers, and also special thanks to Mr. Ram.
In fact, I'll do the honors of the thanks.
Thank you.
Sorry for my military approach, but that's the only way that you can bring order to the conference.
I wish the governments would work this way.
Very soon I'll be also part of the government in some form or the other. But having said that, thank you very much, Rajesh and team. A big round of applause for them. It was really an interesting debate. And may I call on stage Mr. Kaviraj, Secretary General of INBA, to do the honors, please, for our esteemed panelist. To start with, maybe with Ms. Napinai. Yes. Kavi, you should have just seen this side so that. Yeah. Thank you, Mr. Vijay Shankar. Mr. Rajesh, thanks. Big round of applause for you for this unrelenting. Indraneel, thank you. Kavita, thanks. And finally, Shujinto. No, one is still left. Sorry. I miscalculated. My maths is terrible. Thank you. Thank you. Thank you once again, the panel. And which is titled Data Privacy and Data Protection in the Context of Outsourcing Contracts. So may I call on stage Kavita Gupta, Senior Legal Counsel, INBA-IAPP Hitachi. And joining her on the panel would be G.V. Anand Bhushan, General Counsel, INBA-IAPP Cognizant, Mr. Joginder Yadav, General Counsel, India Cisco, Shivram Nair, Executive Vice President, Company Secretary, General Counsel, Ethics, Memphis, right? Then Ms. Sunita Jagtiani, General Counsel, Mahindra Comneva, and Mr. Vipin Agarwal, India Chair, BSA. May I have them on stage, please? Big round of applause for all of them.
Introduction. So before having a dialogue with eminent panelists, I would like to run through a PPT to give an overview about the new data protection regulation. So let's understand how is personal data defined under the European directive. It says that any information that can identify an individual would amount to personal data. In case of outsourcing contract, we usually deal with employee data, customer data, or supplier data. So you would notice that even an email address does constitute a personal data when it comes to European directives. Under the European directives, which was adopted in 1995, the three key principles that was laid down was transparency, that is every data subject needs to be informed about the processing of his data, access of data to be processed, and the right to rectify or delete his data. The data should be used only for legitimate purpose, and it should be processed only if it is adequate, relevant, and not excessive. So this is the current regime under the European directive. This slide shows the new regulation that has been introduced under the data protection regulation. This would be in effective from 2016. The key changes are harmonization on data protection laws in with respect to all the European countries, and one-stop shop when it comes to a single data protection authority, thereby reducing the administrative burden. Every company is now required to provide a breach on data security within 24 hours or 72 hours. It's yet to be decided. I think there's a lot of debate that's happening on this. And again, the outsourcing contracts contents have been specified in details. For example, now, the entire security would be under the control of the controller, and if the data processor is engaging a third party or a subcontractor, they need to take an explicit consent of the controller and various other conditions, including the security measures. The new information governance requirements have been introduced. Now, as per the new regulation, it is required that every company needs to have a data protection officer. So our role would increase now and become more important. Again, the rights of data subject has been expanded, like the explicit consent of the data subject and the right to of the user to move from one service provider to another by way of port data, the right to port data, and the right to be forgotten, which entitle the person to delete the data online in case if it is not required. In event of any breach of these provisions, the penalties has been increased up to a maximum extent of £100 million or 2 to 5% of the turnover of the company, whichever is greater. The restrictions on cross-border data transfer, again, the data can be transferred outside the European country only if the company has a binding corporate rules. There exists a data transfer agreement between the companies on the basis of the model contract clause, and the transfer is to an adequate jurisdiction. The European Commission has identified certain jurisdictions like Argentina, Switzerland as adequate jurisdiction, and companies complying with the US safe harbor principles. So this is my last slide, and this depicts the data protection laws of the country of various jurisdictions, and this shows the highly regulated countries. Recently in US and Russia, there have been strong measures to control the data privacy of citizens. And I think we are also seeing new laws coming up in Asia Pacific region. So these are the few of the changes that has been brought up under the new data protection law. And moving the table to our panelists. So given the backdrop of the new data protection law, the one question that comes to my mind is, why do we need to worry about the data protection law in the context of outsourcing contract when we don't have any presence in UK, we don't have any assets lying in UK, and especially, like we don't have any personnel as well in UK. So I think my question would be to Anand. Anand, what do you think, and what is your take on this?
All right. I don't want to give an overly technical answer. I just want to do a sample. How many non-lawyers in the room? Majority, significant presence of non-lawyers. So why is it important? All right. Actually, the tragedy in India is it's still not considered important, right? Your data privacy program is a small component of your large compliance program. You have corporate governance, sub-components like CSR, insider trading, Foreign Corrupt Practices Act, and data privacy in the mind space of your executive management, your legal department, despite this very fancy seminar, is actually a very small component, right? And that's your first challenge. The perception of it.
That shows sometimes technology doesn't work in technology conferences.
Right?
Maybe it's a precursor to the same.
I think you can speak, people can stay here.
Yeah.
Be very loud.
Booming voice. Stand up and command the mic. So, mic testing? No, it's still off. So now, how are you dealing with this, right, within your companies, and how are you trying to sensitize them? And the best way to do is a scare tactic. I like that. I like that multi-million-dollar fine or dash percentage of revenue. If you want to scare your company into doing something, show them a law with a high penalty and you'll get detention. But on a more serious note, why is it important? For most Indian companies, they've not paid attention to it because they're actually in the manufacturing sector to a large extent, or if they're in the services space, they were too small for them to even worth being sued. And the companies that have become multi-billion-dollar conglomerates have grown so fast, so haphazard a manner within a 5 to 10 year window. They are focusing on immigration issues, they're focusing on general corporate governance, statutory norms, to even go to the so-called secondary issues, right? So these are your challenges. There are mindsets issues like not wanting to invest in compliance. There are other more important matters. And now, how do you connect the dots and make it important for your company other than the bogeyman of fines is, it depends on the type of industry you're operating in. So if this is a battle you guys want to fight within the legal department of your companies or within the, the security divisions of your company, find out what is the type of company. If you're a retailer, Target story was all over the paper. The significant loss of profits by virtue of their customers' credit cards being leaked was damaging to their reputation at an unparalleled scale that sunk both their CEO and CIO's careers. The Sony nightmare was also well known. It's been a terrible last couple of years. First their PlayStation network went down, then afterwards the entertainment division networks went down. So if you are a company in the e-commerce space, high consumer interaction, you're dealing with a lot of personal identifiable information, you're a hospital dealing with patient healthcare information, the single sentence reason.
So now that we know that why it is really important, I think my next question is, on compliance program. One size does not fit all when it comes to privacy programs. So my question is to Shivram. Shivram, you're the ethics officer for Emphasis. And what do you think? Like, what is the leading practices a company needs to follow while implementing the data security and privacy program?
Can you just take us back to that map?
Okay.
See the red part where the stricter regulations on the data privacy and data protection. That is where all the IT companies in India gets business. 70%, I'm just giving a thumb thing, 70% of the business comes from these red areas. So they are the data exporters, they are the data controllers, but they would give all the obligations, the liabilities, the penalties, as Anand said, would be flowing down to the IT vendors here. So it's very important. Now what we should do, firstly, every company should be identifying and implementing baseline controls. And these baseline controls for data security and privacy, these should be mapped to the existing laws, to the privacy principles, and then what you do, you make policies, procedures aligned to it, get it audited. So this is the minimum thing one has to be doing. Second is, as a legal department head, you should ensure that there is an inventory of the data privacy regulations, geography-wise where your customers are, industry-wise where your customers come from. So this is very important. Then have a process to update it on a regular basis. You can have some technology controls having the correct user right assignment. What does this mean? If you are asking an employee to work on a project, give him only whatever information he requires, not anything more than that. Or if any user has to be giving a permission, give him only, or a approval, give him only information what is required, not give more information. These are all risks, right? Actually, so somebody has to be auditing. We also have done external audits, found gaps and corrected it. So that's how. Then physical and logical separation, which is very important. We ensure that there are ODCs, people who come in cannot come in where there are personal data involved. People who come in cannot be bringing pencils, papers, mobiles. They are frisked, nothing to the production floor. So there is, no photos taking. And as far as possible, actually, you should work with the customer to say that I don't want to store the data. Let us have a virtual desktop interface over here. So data cannot be stored. You might have to it will be looked as a transfer from those countries, data coming in, but lesser controls can be put over in the Indian stage. And finally, this is our experience, having your chief risk office representatives talking to the customers customer CRO has always helped. So some of the controls. Yeah.
That's really, I think, one of the best practices that company needs to follow when it comes to data privacy and data protection. But this brings to my mind, like, what about cloud computing? The data are stored in clouds in multi-jurisdiction. The data centers are located in multi-jurisdiction. So what could be the compliance checklist when it comes to cloud computing? Jogidam, would you like to take that thing? I know you have shared with me some compliance checklist.
If you can put up the checklist, of the information security management system.
I would request somebody to help me on
the market some of our cloud services. So we have Cisco cloud infrastructure.
Is that allowed? Is there a Cisco name?
This one, checklist.
Well, so Cisco doesn't only talk about the cloud, Anand. We have intercloud, right? So when the internet came up, internet was nothing but, making computers talk to each other. Cisco's making clouds talk to each other, right? And the basic premise of intercloud is that you have the privacy and the data protection principles in the cloud are not very different when you do on-prem, right? Your data is on-prem within your systems or within two companies, it's being exchanged. Cloud just lends a different layer of risk to it because it's supposedly not in your control. But if you implement,
I think this is the one.
If your company implements these 12 or 13 controls, or what are the attributes of a good information management system, this is public information. I'll send you all later through the organizers the white paper that holds this information. So you have information security policies. We're not new to that. So which would include things like segregation of duties, contacts, what's the management and structure of organization to, you have multiple CISOs in the room, so I'm sure we all aware of that. Human resource security, screening background checks, because humans really cause information theft, right, at the end of the day. So if you get the right people on board, that's a very important aspect of maintaining data privacy and data protection. Getting, disciplinary actions, I think enforcing your policies is equally important, not just having policies. Asset management is very important, and out here asset refers to information assets. So most countries have their, data retention laws and regulations. I think if you keep those in mind, there may be certain instances where you store information for a little longer than that because it meets a certain business purpose, or contractually you're committed to customers to store the local law requirements, so you can certainly do that. So classification of information is very important. Access controls, Sivaram talked about that. Cryptography, what level of encryption you have, especially when data is being exchanged over the internet, the public internet. If you go down a little. Physical environment security is important. So physical environment security and environmental security is important. There could be environmental threats that could come on your organization, which could lead to failure of logical, physical and virtual threats. Operation security, certainly, the policies that are administered by the CISO. Communication security across the net, basically. I think system acquisition, development and maintenance is often overlooked. And here you have security requirements. We all know what happened with the regulations that came out by the DOT, or they were issued by the DOT in 2011, right? Basically in response to the perceived threat from the Chinese vendors, which was supposed to have spyware or malware in them. So it's important to buy equipment which subscribes to certain standards and enables you to deliver the level of data security and transparency and reporting that you need to develop confidence. Supplier relationships, I think this is an important aspect, especially when you're outsourcing to different, as a customer, as a data controller, you're outsourcing to outsourcing providers across shores. It's important to have policies and monitoring of those policies. Information security, incident management, and business continuity management, including disaster recovery. I think those policies are important. And lastly, but not least importantly, is compliance, right? So when you talk about compliance, it could be with respect to contractual arrangements that most Indian service providers have with their customers across various jurisdictions, as well as, mandated, for example, if you're getting data from the EU, you need to sign up to model clauses. So that's important. And that's going to change.
Yeah, I think, you have already covered the, mandate that is required under the new data protection regulations. So it seems like Cisco is already prepared with it and ready to tackle the new regulations. And this list is really comprehensive and exhaustive, I'm sure.
There are a few things below just to ponder. Threat intelligence is something that is very important. Okay. So this is common knowledge, but I thought I'll share a comprehensive list. I don't think I put it here. I put it in my other document. So threat intelligence is very important. A lot of companies are setting up teams which their sole job is to identify threats, both internal and external, but mostly external because there are a lot of hackers around. You make sure you get the right people on board, but you can't control the environment outside. The other is big data, right? Do you sacrifice privacy to big data? I think you should not. So if your company is looking at using big data to make business decisions or even internal decisions, it's important to have a system where you can anonymize data, right? Where it should not be capable of identifying individuals. You can have subsets of people identified. So I think these aspects are equally important in this day and age. Anand got a little bath. So, it's just water, it's fine.